My name is Dr. Elifuraha Laltaika. I teach law at Tumaini University Makumira in Arusha, Tanzania, but I also serve as a member of the UN Permanent Forum on Indigenous Issues. This is a UN body working under the Economic and Social Councils with different mandated areas, including economic and social development. But I also co-founded the Association for Law and Advocacy for Pastoralists, and this is a grassroots organization working on the rights of traditional cattle herders in northern Tanzania. In understanding the functions of and the effectiveness of the UN Permanent Forum, I think it's important to first of all understand the forum in the context of representing UN commitment towards indigenous people's issues. This means the UN has really following struggles by indigenous peoples, seen the importance to have some space within which indigenous people's disadvantages can be highlighted at the international level. So one of the functions is really to work on mandated areas of the economic and social councils, including social and economic development, the environment, the economy, areas that really represent core issues of indigenous peoples. And talking about effectiveness, we can see it in opening up the spaces for indigenous peoples to access the UN and narrate their disadvantages compared to mainstream communities in their respective countries. But another effectiveness can be seen in really providing the space for normative development. We know, for example, that the UN Declaration on the Rights of Indigenous Peoples was a result of spaces like that where indigenous peoples would access the UN and negotiate their future. The answer to that, first and foremost, it's obvious on the part of indigenous peoples that the UN, engaging the UN has worked in their favor. And one of the concrete examples, as I said, is the enactment, the coming into being of the UN Declaration on the Rights of Indigenous Peoples, which is widely regarded as the most comprehensive international law embodying rights of indigenous peoples. And this document, unlike other declarations in the United Nations, is really a result of engagement of indigenous peoples themselves. So they come to the UN armed with that concrete evidence that the UN, despite its challenges, works in their favor in becoming a bridge towards their nation states that form membership of the UN and catalyzing their struggles on the ground. But another reason why indigenous peoples come to the UN relates to the mandate of the UN as embodied in Article 1 of the United Nations Charter, that the UN has the role to play in ensuring peace in the world. And therefore, indigenous peoples believe that the UN, despite its challenges, despite being a membership organization of nation states, has the role to play in making sure that peace prevails globally. In understanding the strength of the African regional system and the UN global system, in terms of indigenous people's rights, it's important to know that these are institutions that set the minimum standards of treatment of indigenous peoples by their nation states. So they develop normative frameworks and jurisprudence relating to how indigenous people's rights should be respected. And therefore, at the UN level, we have two important normative frameworks, namely one, the UN Declaration on the Rights of Indigenous Peoples, and two, the International Labour Organization's Convention 169. At the African regional level, we have the African Charter that has created two institutions, the African Court as well as the African Commission on Human and People's Rights. The importance collectively is really to set the minimum standards or normative framework that can be followed by countries in treating indigenous peoples at the country level. The African Court on Human and People's Rights is a creature of the African Charter on Human and People's Rights, and it sits in Arusha. Now, it's a relatively new institution, but already it has decided a landmark case involving the Ogiek hunter-gatherers from Kenya. So that is the main contribution of the African Court in terms of indigenous peoples, because it has brought clarity around the concept of indigenous peoples. The concept is not clearer in Africa because there's contestation on the part of a number of governments, but the court has built on a great work of the African Commission on Human and People's Rights to really clarify that in fact there are indigenous peoples in Africa and they have a set of rights recognized under international law. I think the most important thing for human rights scholars and the activists is really to remember that the work of human rights observance and promotion should start at the country level, and that the regional and the international level are just pace setters. They set the minimum standards that require implementation at the country level. So advocates should keep that in mind and make sure that they work on the ground and just get inspiration from the complementary works of the regional and global human rights institutions.